All right. Hello, everyone. This is Ann Badmus. Welcome to our webinar, our June webinar, Winning a Green Card Through PERM Labor Certification. Again, welcome. I'm Ann Badmus, and I look forward to presenting to you today. Just for purposes of technology, to be sure everyone can hear. If you can hear me, please place in the chat. Yes, I can hear you. So I'm going to put in the chat some information. Yeah. So hopefully, if you can hear me, anyone there, thank you. Thank you so much. I appreciate it. Okay. So let's go ahead and get started. We have some people still coming in, but we'll go ahead and get started because I want to be mindful of your time today. And again, thank you for joining us. If you have any technical difficulties, go ahead and use the chat button. But if you need to ask a question, which we will have time, hopefully, to answer questions, please use the Q&A, bubble at the top of your screen to the right. You should see a Q&A or somewhere on your screen, whether it's on a phone or whether it's on a computer, you should be able to see the Q&A information there. So use that question bubble in order to answer your question, to ask your questions. That will be the best way for us to be sure that you can get your questions answered, and we can track those questions as well. And also for confidentiality, because we do have a lot of people on this forum, we do ask that you ask questions in a general manner. Please try not to include personal details, just for confidentiality, so that your information is kept confidential as well. So just a little background on us. Let me see if I can remove this as well. Okay, just a little background. So our law firm, for those of you who may not be familiar with us, is Badmus Associates, and we've worked with clients, thousands of clients since 1993, and have received very numerous awards for our work. Also, I wanted to let you know, as I mentioned before, this is an open forum, but the information that we're providing here really is very much that. It's information. It's not legal advice. It may not be pertinent or applicable to your specific circumstances. So it's very important that if you do have a specific concern or would like to have advice about your situation, that you should consult with one of our immigration attorneys or another qualified immigration professional. With that being said, let's go ahead and get started because we have a lot of ground to cover. So I want to make sure that we cover all of it. Our agenda today is we're going to talk about, as the topic says, PERM labor certification, which is part of the one part of a green card process. So we'll do an overview of what PERM is, how it plays into the green card process. Then we'll go deeper into PERM itself, as much as we can in the time allotted. There's certainly a lot more information that we can't provide, but we will try our best to do so. So basically, the PERM labor certification nuts and bolts, we'll talk about that. And then we'll talk about what happens after a PERM is approved. What are the procedures to know about after a PERM is approved? And then we'll have time for Q&A. So again, remember to, as we go along, if you have a question, go ahead and put your question into the Q&A chat so that we can address that as soon as the presentation is done. So as you can see, green cards is a very complicated process. There are very many ways to get a green card, which is permanent residence in the United States, and permanent residence leads to citizenship. So if you're looking to eventually become a citizen, or even if you're not, but you want to have the ability to be in the United States permanently without having to renew visas, that sort of thing, then a green card is the route to get to that point. So let's talk about the PERM labor certification process. I'm not sure if this is going to be in the way or not. I'm trying to reduce that. Okay, so the PERM labor certification process. Who needs PERM? So I will say PERM actually is probably by far the most used process for someone to get permanent residence through an employer's sponsorship. So if you are a foreign national worker who does not have a family member that can sponsor you for permanent residence, then more than likely you're going to go through the employment route. And so PERM is necessary for anyone who is applying for a green card through an employer sponsorship, unless you can qualify for an EB1 category, as I list here, or an EB2 national interest waiver worker, or an EB4 special immigrant worker. So those are different categories. We're not going to discuss those here, but those are other routes, very specific routes to qualify for permanent residence. So if you meet those requirements. So if you don't meet those requirements, then PERM more than likely is the way that you can go to get permanent status or a green card in the US. So what is PERM? PERM is basically an acronym for Program Electronic Review Management. So that basically means it's basically a process through the US Department of Labor. So it is the initial step where the US Department of Labor is charged with making sure that if someone is sponsored through by an employer, that foreign worker is not taking the place or taking a position that could go to a US citizen. So the job primarily, or the policy primarily for the Department of Labor, is that they want to ensure that they're protecting US workers and their ability to work in the United States ahead of foreign workers who might be here or be sponsored through the process. So for that reason, there are very specific requirements that an employer must do in order, or must meet in order to get their PERM application approved. So before we talk about the nuts and bolts, as I mentioned, I want to discuss the PERM categories. So many of you are probably familiar with, there are different categories of employment-based sponsorship. So we have, so the reason I'm listing these here is because it is important, as we'll see later, in terms of the processing time, or how quickly you can get a green card. Depends on what category that you are applying for through your PERM process. So through PERM process, you have four different categories that you could be considered for. So first, there is the EB2 advanced degree professional. I'll talk about that a little more in detail. Then you have the EB3 professional worker, an EB3 skilled worker, and an EB3 unskilled or other worker. So what does that mean? So if you are applying as an EB2, let me just make sure I switch this out. Okay. If you are applying as an EB2 advanced degree professional, then that means that you have either a master's degree, or you have a bachelor's degree plus 5 years of progressive experience after your bachelor's degree. So if that kind of qualification is required for the job that is being offered to you, so for example, if you're a doctor, then certainly you would meet this category as EB2, because the job of a doctor does require an advanced degree beyond a bachelor's degree. So if you meet that qualification, then you would be qualified for EB2 advanced degree. Now, one thing to note here, I just wanted to briefly note on our last bullet point here, if you do not have an actual degree, but you have a lot of experience, that might help you to qualify for another, like EB3 category, but it would not qualify for the EB2 advanced degree professional. So you would have to actually have a degree from a university in order to meet this. You could not equate your experience to a degree requirement. So the next category is EB3 professional or unskilled worker. So these are pretty, although they're distinguished as categories, they really aren't very different in terms of timing. They aren't different at all, actually. But what is different is the educational requirement. So if your position that you are being employed by, or you as the employer, if you have a position that requires a bachelor's degree, or if you require a bachelor's degree, then that's a professional position. or if your position only requires at least 2 years of either post-secondary, post-high school education, or for example, an associate's degree, or if it requires some experience, trade experience or something like that for at least 2 years, then that is an EB3 skilled worker. And then, of course, if you do require that, you must show, or the employee must actually have that required degree. So you can't require a degree that the employee cannot have itself. So that's very important, as well as we'll see later as we go through the process. I did not mention EB3 other workers because that actually, which is unskilled workers, it pretty much encompasses anyone who does not have that skill set of either a high school diploma or having 2 years of experience or education beyond high school. So next, why was that important to discuss? So why it's important, the EB categories that you choose or how you fit under the PERM process is important because, again, as I mentioned, timing. There is a quota every year starting in October that the federal government says we will have 140,000, let me see, around 140,000 green cards available for employment-based applicants. So there is a limit on how many green cards are issued every year under these categories. And they give priority to the EB1 workers, then it goes to EB2, then EB3, and then EB4 special immigrants. So we don't have a lot of information as to how they calculate the availability of those visas. There's some notices that they give out, and we'll talk about that. But the calculation itself is pretty complicated and is pretty much kept under wraps with the government. They make calculations to determine how many visas are being used and how many are being left, or how many are left to use each fiscal year. So before we go on to seeing how looking at those looking at the queue that exists for these types of categories, one thing you also need to know is when we're looking at that green card annual quota, the quota is divided not only by the numbers of visas or the category of visa, EB1, EB2, EB3, but it's also divided amongst the country based on your country of birth. So there is a 7% country limit, which means that pretty much all countries almost evenly get a certain number of visas. So if you come from a country that has a lot more immigrants coming from that country, it's going to be a longer line, a longer wait for you to get a green card as opposed to other countries. And then again, it's, as I mentioned, it's based on country of birth. So it doesn't matter if you have another citizenship, if you were born in one country. So for example, we'll use India because that tends to be backlogged. So if you were born in India, but you're a Canadian citizen, you do not move out of the Indian country of birth queue. You are still under EB2 India or EB3 India or whatever category that you're employment-based category that you're applying under. So it really does not matter as far as a subsequent citizenship. What really matters is your country of birth. And then the other kind of rule that is an interesting rule, it's a very good rule that we think helps some people to move ahead or not be limited to a country where there is a long quota. And that's what's called the cross-chargeability rule. So what that means is that if your spouse has a different country of birth and it is in a faster category than your country of birth, then you can use that your spouse's country of birth, even if your spouse is not the primary applicant, but in fact your spouse is a dependent applicant. You yourself are the employee applicant, but your spouse is also going to apply with you. And if they apply with you, then you can use their country of birth, which can actually move you ahead move you ahead into a faster line if that applies. So again, if you were born in India, but your spouse was born in England, then you can use the England or UK line, which tends to be much, much faster than the India line in order to apply for your green card or get your green card faster. So how do we look at that? What we have to look at every month to determine whether or not an individual or a client is able to either apply for the final step of the green card process, the adjustment of status process, or immigrant visa process, or whether they're able to finally get approved for the immigrant visa process. So how do we calculate that? Well, what's important to know is your priority date. So if you're going through the PERM process to get the green card, then your priority date is established by the date that your PERM application through the Department of Labor is submitted. So once everything is done in preparation for PERM and you and your employer submit the PERM application, if it was submitted today, June 22nd, 2023, then that is your priority date. And assuming that everything else, your next step is approved as well, then that priority date is what you would use to look at whether you can actually go to the final step, the third step, which is the adjustment of status process. So as you can see here with this chart, we have the employment-based categories on the left column, EB1, EB2, EB3, other workers, which is also EB3, fourth category, special immigrant, and then some other categories that we won't get into. But essentially, as you can see from the chart, there are specific columns for certain countries that tend to have a higher level of immigration. So you can see there tends to be a little bit of a backlog in those categories. So for example, if you look at EB2 India and EB2 China, there is a backlog of May 1st, 2012 and July 8th, 2019, respectively, which basically means that the applicant is unable to apply for either filing the adjustment of status or unable to apply for adjustment of status unless their priority date is before these two dates. But as you can see, for other categories or other countries, the dates are a little bit faster. But in this case, it is notable, and this is an older chart, but it's pretty much the same for this month and next month as well. We can see that even the rest of the world in the first column here, all chargeability areas except those listed, you can see that there is still some backlog there as well. Oftentimes there isn't a backlog, and usually in October or so it does kind of clear up and it tends not to have a backlog. But depending on the number of applicants each year and the number of approvals each year, even the rest of the world categories can also be backlogged. So it's important to be mindful of this chart. So that's why the EB categories are important. And when you start with your PERM application, it's important to determine, first of all, what category that you're going to fit into, and then also know how long it might take you in order to actually get your final green card, as an estimate, because there is no bright line. There's no specific time that the government says it will take us. They don't guarantee a processing time. So all we're doing is just estimating how long it might take you to get your green card based on these numbers, these charts. So nuts and bolts of PERM process. And again, I want to remind you, if you have questions, use the Q&A panel, which is at the right of your screen where the bubble that has a question mark. That's the best place to put your question rather than in the chat area. Okay, so before you even start, whether you as the employee or you as the employer, both parties, before starting, have to consider certain things because it's very important. It is a very detailed process. PERM is a very detailed process, and if there's something that is incorrect, it could derail the whole process for you and cause a denial. So before you apply, the attorney and the employer and the employee need to understand, first of all, the employment job itself. So some of the things to think about that we usually ask clients as part of our process is, does the employee own any part of the company? As an owner of the sponsoring company, sometimes you can be an owner. For example, if you have 5% or less, you can be an owner. Sometimes if you have more than that, you can still be an owner and be sponsored through the PERM process. But it is a more difficult case if you are an owner. So it's important to know the ownership status, but also not only that, we need to know if there's family status. So for example, if your brother is the owner, then that has to be disclosed in the application. And again, it does not mean it cannot be approved, but it has to be disclosed. So that's information that's very valuable and needs to be accurately represented in the application. If the position has any travel requirements, that does tend to change the wage requirement, which we'll discuss in a minute, but travel requirements. So if you have a traveling job that has different sites that you have to go to, or if you have to travel, like, for example, if you're in sales and you have to travel 50% of the time, those kinds of things need to be disclosed as well. What's another one that's really important, we are hearing about layoffs, and certain industries are having layoffs. So if you are a company or that it has a layoff or has had a layoff within 6 months, and that layoff is for the same position that you're planning to sponsor your employee, your foreign national employee, then that can be an issue. It actually can cause a denial because if you've laid off U.S. citizens for the same position, then the Department of Labor can consider that you're favoring a foreign worker over a U.S. worker. So that is an issue that needs to be addressed and looked at before applying. And also, finally, if there are anticipated changes in the work locations, because PERM is very location specific. So it is important that you also list, you also know exactly where the employee is planning to work or is going to work. And if there are multiple positions or multiple locations, we need to know that. If you expect that you might get a promotion within the next a year or so that's going to be very different from the job you're in now, then that might be something to consider as well, because again, PERM is also very much position specific. So if you're changing into a different job that might be a lot different than the job you're in now, then we might want to consider waiting to apply, or actually using that job position as the future job position as the PERM position rather than the one that you're in right now. So these are some of the considerations, definitely not all, but these are some of the ones that should really be considered or really noticed as part of this process. So PERM requirements, what is required? Now, these again are very general requirements, but this is the typical requirement. So PERM applies to all full-time workers. So first of all, the position being offered has to be a full-time job, or the position being sponsored has to be a full-time job, not a part-time job. And I list here that it doesn't include university teachers, nurses, and physical therapists, because it's a different process. There is a PERM process that's applied, but it's not the PERM process that we're going to talk about. And we'll talk a little bit about those processes later. What is required for this particular PERM process is that recruitment must be done within 180 days before you submit the PERM application. So one of the things that we have to look at and decide is, how are we going to test the local market being where you live or where the job is located. So essentially what we want to do is determine do a testing of the local market as prescribed by the Department of Labor. They have very specific requirements, which we'll talk about in a minute. The employer must agree to pay the prevailing wage or higher once the worker receives their green card. So that's something that often comes up. If the prevailing wage is higher than what you are currently being paid, the employer would have to agree to pay that wage in order to go forward. But if they don't have to pay that wage immediately, when they have to pay that wage is when you actually receive your green card, which could be 2 or 3 years later. It could be 10 years later, depending on where you are on the visa bulletin chart there, or how long it takes you to get the green card. So we always tell employers that even though if you think that you can pay that wage in 2 or 3 years when it's anticipated for the green card to be approved, then you can go forward with the application. Other requirements include making sure that the job position, the duties and qualifications are typical, they're customary, they're not something unusual that it would look like that the job is being tailored for a particular applicant or for the foreign worker. The government is very much does not like a job that looks like, oh, we are doing, this job is going to, the only person that could meet this job ever would be the foreign worker, because we're asking for the specific degree that the foreign worker has, even though we could accept other types of degrees, or we're asking for the specific experience that the foreign worker has, even though we could accept other types of experience. So again, this must be a typical, usual duties and qualifications that you have had in your own business or own company for many years, or is the typical job duties that across the industry itself. So you can't have really restrictive job requirements, for example, a foreign language requirement, unless you have a business necessity for that. So oftentimes, sometimes we're asked, well, what if I need, different language ability? Well, you would have to prove that that language ability is used in that job, is absolutely necessary for that job. Of course, something like a translation job, that would be easy to prove. But if it's not something like that, then you would have to show that the worker is using that foreign language almost daily in that position, and it's absolutely necessary that they do that. And then finally, as I mentioned before, job requirements cannot be tailored to the foreign worker. Okay, so the next step, the first step that we do once we determine the job, make sure that the job is meets all the requirements that I just discussed, then we determine the prevailing wage, because as I mentioned before, the employer has to agree to pay at minimum the prevailing wage at the time that the foreign worker gets their green card. So what we typically do is check the government's typical wage survey, which is shown here on this slide, where we show the website where you can go and determine what the government thinks should be the prevailing wage. If that wage is too high, you can potentially use alternate surveys, but those surveys have to meet the government requirements to be valid. Once that's done, then you submit the prevailing wage determination request, and that is submitted online to the Department of Labor, and then we wait. Unfortunately, we have experienced the government has experienced a lot of delays in issuing prevailing wage determinations. Sometimes it's taking them more than 6 months. Actually, they're saying it could take them 12 months or so to actually submit it. So it's a very long waiting period sometimes for this. And that's why we really pretty much just wait for that before we go forward to the next step of recruitment. Because we keep in mind, as I mentioned before, recruitment has to be no older than 6 months or 180 days before you apply for PERM. Well, but you also have to have the prevailing wage determination. And if you don't have the prevailing wage determination and your recruitment has now been more than 180 days, you have to start over again. So to save cost and to be timely with the recruitment, is usually best to wait until the prevailing wage is actually issued, and then move to the next step of advertising and recruitment. So on this slide are the different recruitment requirements by the Department of Labor. So we can't just use any recruitment that the employer might have used in the past. We have to go with the specific prescribed recruitment, which always includes a job order with the State Workforce Commission for 30 days. So that is what is a typical website that all states have, where they post jobs. And this is usually through, for example, in Texas, it's the Texas Workforce Commission, which is their departments of labor, typically administering unemployment benefits and things like that. So it's important that we post that job order for 30 days, then 2 Sunday newspaper ads in the local newspaper of the widest circulation. That's the minimum, and that applies for skilled workers and for other workers. Now, if you're a professional worker, meaning that your job requires a bachelor's degree or higher, then you will need 3 additional ads in, you have a choice out of 10 potential recruitment processes to do that. So for example, posting on a website, posting on a third-party website like Indeed, something like that. So there's different options, and we as attorneys will work with you to determine work with the employer to determine which are the best options to go with. Then the employer also has to do a notice of filing or job availability for 10 business days. Now this is posted on site where the position is located. So the employer is responsible for making sure that is posted for 10 days. And then you finally have a recruitment report and resume. So all of this is actually the employer's requirement. The sponsored employee has no input into this process because it has to be neutral, so that the sponsored employee has no influence over this process. So when we talk more about the advertising, what's very important is that the ads have to identify the employer. So it can't be a blind ad which does not identify who the employer is. All the responses have to go to the employer. The ad must be detailed enough so that people could know, what is this job about? You know, it's not just putting a title out there, but putting a short description of the job opportunity. It must indicate where the job is located. And while the wage is not required, in most cases, we stay away from putting the actual offered salary in the ads. But if you do put the salary in the ads, then that salary must be equal to or even more than the prevailing wage there. So the ad requirements are very specific. That's why we typically can't use previous advertisement that companies might have used in the past. Also, it's important that once the advertising is in place, whoever is responsible or the representative of the employer needs to immediately review any resumes or applications that are submitted in response to the ad, and also need to contact, if those resumes or applications appear to meet the qualifications of the job, then the employer representative or HR person, whoever that is, needs to reach out and contact applicants for interviews. Once the interviews are done, if there are any interviews, then the HR or employer representative needs to document how the persons were contacted, what the outcome of the interviews were, why that person was not qualified or not chosen for the position. Now, you do not have to choose or hire anyone for the position, but since if you want to proceed with the process, you do have to explain why the people that you did interview were not qualified, or the people who did apply but maybe were not interviewed, why they were not qualified and why they were not interviewed or accepted. Next step is, again, same thing, provide those objective reasons, screen, all those things that I just said. So pretty much this slide summarizes: you need to analyze the qualifications of the applicants, you need to screen and interview if appropriate, and based on your usual company process. You can't do something totally different than what you normally would do when you're hiring. And then you provide your reasons, objective reasons for rejection of any applicants. Next, as far as employer requirements are concerned, the employer must maintain documents of recruitment efforts for the 5 years from the filing. So all these things that we talked about, as the attorneys, we will help to be sure that you have provided all that information and have a file that you keep all that information in, that shows what you did as far as recruitment is concerned. You also will have a detailed recruitment report that explains your recruitment efforts and explains how many people applied and how many were rejected. So once all that is done, we have the prevailing wage determination, we've done the recruitment, then the next step is to apply for PERM. So PERM is an electronically filed application. They actually, for many years it has been, and they've just moved the PERM application site to a new website, as I've shown here on this slide. And then you should prepare the ETA 9089, which is the actual PERM application. Before submitting it, both the employer and the employee should review it, make sure everything is accurate. And then once it's confirmed, signed off that it's accurate, then submit the application online. Now, the people who can submit these applications are the employer or the attorney. Employees cannot submit these applications. So employer and or the attorney would be the ones who can submit this application and track the application internally within the PERM account that's set up for the employer and the attorney. So employees have no access to that. But you can access processing times. So what you can do is go to this website that I have here, same website, and access processing times, and you can see what the processing time typically is for PERM applications there. And typically right now we're looking at least 6 months or more for PERM applications once filed. The last thing to do as in preparation or as part of the PERM process is to prepare for a possible Department of Labor audit. Now, most PERM applications are not audited, but what does the audit mean? The audit is basically confirming that the employer has indeed done the recruitment as stated in the PERM application, has kept a record of the resumes or applications that have been submitted, have proof as to why they have any special requirements. So all those things need to be in the PERM file, as I mentioned here: recruitment report, prevailing wage determination, the advertisements, the recruitment results, and any documentation of business necessity for if you have any special requirements. All that needs to be there and available, because if you do get a PERM audit, you only have a limited time, about 30 days, to respond to that audit. So you have to make sure you have everything in place and ready to go as soon as you get an audit request. So other things you have to know about: when does a PERM audit get triggered? Because you can get a PERM audit because if your job duties don't seem unusual, doesn't seem to be the typical job duties for the occupation, if you are asking for experience that was gained while the worker was working at your company, if you have foreign language requirements, if your employee owns part of the business or has a family relationship, or if there's been a layoff, as I mentioned, those are things that can trigger an audit. So what are the obligations for the employer? Employer needs to know that they must pay all PERM processing costs, including attorney's fees and advertisement costs. The employee cannot be required to reimburse the employer for any of these PERM associated costs. Even in the future, should they leave the job itself, you cannot ask for reimbursement just because they left the job. You cannot ask for reimbursement at all. Another quick fact is that you have to confirm that there are no qualified U.S. citizens or permanent residents that responded to the recruitment. So when we're doing the recruitment, we are showing that we could not find U.S. citizens or U.S. permanent residents or even U.S. asylees who were qualified for the position. If you get responses from people who also need PERM sponsorship or who are on visas, they do not count as U.S. workers. Another fact is that you have to be sure that the employer is the one taking charge of the recruitment. You cannot have the employee involved in any way, screening resumes, determining the job requirements, even emailing the attorney about the job itself. Those things are no-nos because, again, it has to be an independent process where the employee is not involved. Well, before I go on, again, I want to mention, please move your questions over into the Q&A section, not the chat section. Finally, the last two areas I want to talk about briefly is for those who are applying for university teaching positions where classroom teaching is involved. There is a special process, PERM process, called optional special recruitment. And what that means is that it actually is a little easier process than the recruitment process that I just mentioned. Here, you do not, the timeline is longer so that the PERM application can be filed within 18 months from the job offer. You can also use a single advertisement, and that advertisement can be well before the PERM application is filed. But what's really most interesting for this type of PERM is that the most qualified is the standard of selection. So what I mean by that is that when you're doing a typical PERM application, the employer cannot say, oh, well, the foreign worker is more qualified than all of these others, even though these other applicants are qualified. Our applicant, our foreign worker, is more qualified, so we want to select that. No, you can't do that. You have to, if those people that apply are U.S. citizens and they're minimally qualified, then that means you cannot go any further in the process of PERM. However, for this type of optional special recruitment for university teachers and professors, you can actually say the professor is the most qualified, the foreign professor is the most qualified, therefore we selected them out of all of the other U.S. applicants, and that's perfectly valid. And then the last area is the Schedule A pre-certification. So the Department of Labor has determined for a very long time that there's no need for any recruitment, no need to show that there's a shortage in the occupations of registered nurse and physical therapists. So it's a really good process for these types of occupations because you don't have to do all this PERM advertising, all these things. You just need to file directly with the U.S. Department of Homeland Security and skip the PERM process and go to the step of I-140 petition, which I'll talk about in a minute. So I-140 petition comes after the PERM approval, or in the case where you don't need PERM approval, like Schedule A workers, the I-140 petition must be filed within 180 days of PERM approval. At that time, the employer must provide their financial records to show that they can pay the salary of the prevailing wage requirement. So they have to provide tax returns or other documents as well. They have to, then you also have to provide proof that the employee is qualified. So that's where we need proof of your education, your experience, all those things that were required as part of the PERM process. And then there's also a premium processing option where you can get a fast track 15-day decision on this type of I-140. So it's very important for employers to know how to evaluate the ability or be able to evaluate their ability to pay the salary before the PERM process begins. So what we look at when we get a new client who wants to apply, we want to look at the company tax returns, or if they have an audited annual report, audited annual financial statements. We need to know whether or not they can show on their financial documents if there's enough income to pay that salary. Sometimes there isn't, and we have to delve into other things, but it's not enough time to go into that. And then next you have to, as I mentioned, get proof of qualifications of the employee. So before the PERM is filed, make sure that you have all your diplomas, transcripts, training certificates, certification letters, letters of experience. If experience is required in the position, we look at all of that beforehand so that when we get to the stage of the I-140, this step 2, we have all that information because that has to be proven at this step. Then the final step, step 3, the immigrant visa application, which I mentioned earlier. This depends on the priority date. So your priority date must be eligible to apply for the immigrant visa, as I showed on earlier. If you are eligible, then there's 2 processing options. If your priority date is eligible, there's 2 options: adjustment of status. If you are legally in the United States, you use Form I-485, or consular process, which means that you will process outside the United States at the U.S. Embassy in your home country. Quick fact to know: if you're a J1 physician, then you are not able to file your J1 waiver physician, you're not able to file your I-485 unless you've completed the 3-year medical service requirement. So that's important to know. Even though you can do the PERM and the I-140, you will still have to wait for either your priority date and your completion of your 3-year medical service before you can apply for the adjustment of status or even the DS-260 immigrant visa. So if you're going to apply for adjustment of status, you need to be present in the United States legally, non-immigrant status, and no status violations for more than 180 days. You can file your I-485 is filed separately for you as well as each family member. As part of the I-485 process, you can also apply for the EAD and the advanced parole travel document. And currently, it can take 12 months or more, although we are seeing faster processing, but the government is not guaranteeing anything. So typically, you can expect about 12 months or so if your priority date is still current and depending on the caseload. Consular process means you have to leave the U.S. and attend an appointment at the embassy and get your immigrant visa there. And sometimes people are already outside the U.S. and this is the only process they can do, but sometimes people will choose this process as well. But you have to know that also it can take 12 months or more, and it tends to be a lot longer. So we don't recommend this. If you can do I-485, that's the best route to go. So tips for fastest processing: you want to be sure that first of all, determine whether or not I-485 or DS-230, which is the immigrant processing, is the best option or available to you. If possible, you want to file the I-140 and I-485 together if your priority date is current. It is, even though premium processing does not necessarily speed up your adjustment of status or your actual green card approval, it is helpful to get your I-140 approved through premium processing as quickly as possible for many reasons. But primarily, the I-140 has to be approved before your I-485 can be approved. So it does make sense to try to get that approved as soon as possible. And if you are stuck in a backlog, make sure you track your dates every month to see if your priority date is eligible by going to the visa bulletin every month and checking that. So that comes to the end of our presentation. We talked quite a bit about the PERM processing. It is very detailed, and employers and employees both need to be very much aware of these processes to understand how it goes, and also understand it's a very long process. It will take at least a few years, depending on where your country of birth and where you are on the priority date chart. But essentially, it is a long process, but it is the most commonly used process. So with that, I will go to questions. I will go to the Q&A section to answer the questions. So far, I see 3 questions here. And if you have a question and you put it in the chat, please cut and paste it and move it over to the Q&A section. So one question that first question that was asked is, can a minister nonprofit organization file for PERM? Yes, there is no restriction on the type of organization that can file for PERM. It can be a nonprofit, it can be a for-profit, but what is important is that they can show still the ability to pay whatever the salary is. So if the salary is $50,000 a year, that nonprofit needs to be able to show that it has either the assets or the income or the bank account to pay that salary. But yes, a nonprofit can sponsor any employee, including a minister. Okay, so the next question is, what type of document evaluation is required for someone with foreign degree before attempting EB2? So that's a good question. So basically what you need is to get a credential evaluation from a qualified and approved credential evaluation company. There are many of them. So those companies will look at copies of your degree, your transcripts, and then they will evaluate whether or not the time that your foreign degree is equivalent to a US degree. So for a master's degree, for example, some people will say they have a master's degree, but it's only a 4-year program. Well, in the US, they typically expect that a bachelor's degree is 4 years and a master's degree would be at least an additional year. So it may be difficult for the credential evaluation company to equate a 4-year master's program, which is only 4 years and there's no other preceding education before that. It's difficult for them to equate that to a master's. They will usually equate that to a bachelor's. So thinking about whether you're EB2, make sure you look at your program and see whether or not, how many years did you spend in education to get that master's? Did you have 4 years plus another 1 year or 2 years or 5 years beyond 4 years? So that's important to know. But there are many of those companies that can do that. And if you're working with us, we will point you to a few companies that can look at your degree and transcripts to determine whether or not you qualify for EB2 or a master's degree level or a bachelor's degree level. Next question is, my employer has started the PERM. Can I simultaneously file NIW? Does this have any conflicts or any effect on each other? So the answer is yes, you can apply for any other process that you think you're qualified for. So even if your employer has started a PERM or even has been approved for a PERM, you can still apply for an EB2 NIW or an EB1 if you're qualified. We have many clients who have done that for different reasons, because the thing about PERM is that PERM is tied to your employer. So if you do leave that employment, you can't just simply take that PERM application and use it in most cases to get your green card. There is a certain stage towards the end of the process where you can still use that PERM process to continue and get your green card. But in most cases, it depends on, you would not be able to use that unless you're in that final stage of the green card process. So some people rather go with an NIW or include an NIW if they're eligible and if they get approved. That is a self-petition, so it's not tied to your employer, and you can take that NIW and get your green card regardless of where you are working or who your employer is. So there's no conflict in terms of doing a PERM and an NIW at the same time, or at one after the other as well at any time. Next question is, can a H-1B visa transition to PERM when they're already here, or do they need to leave the country to their home country for the process? So if you are legally in the United States, you can, on H-1B visa or any other type of visa, just because the PERM process has been started or even has been approved does not mean that you have to leave the country. So you can be in the U.S. and continue being in the U.S. Throughout the whole process, including the last step. You can potentially do adjustment of status so long as you have maintained legal status the entire time, with the exception of about 180 days in the United States. So basically, if you have a clean, good immigration record, then you can apply for adjustment of status and you do not have to leave the United States. However, of course, if you are not in the U.S., some people are actually applied for while they're outside. They haven't been to the U.S., they're living outside the U.S., but an employer has agreed to hire them so that when they come to the U.S., they will come as permanent residents. So, for example, we've worked with a lot of nurse applications where the nurses are working and living outside the U.S., but the employer, they need the nurses, they've interviewed them, and they've decided that they will go through the process of getting the PERM, well, not the PERM process, but the Schedule A green card process for nurses and bring them into the U.S. So that could also apply to the PERM process as well, where the employer goes through all of that process, gets the I-140 approved, and then the employee applies at the embassy for the green card immigrant visa and comes to the U.S. as a permanent resident. But if you are in the United States, then the best way is to maintain your status and then change to or apply for adjustment of status once the process, once you're to that point where you can do that. Okay, let's see. That's the last question I see on the Q&A. Let me just check. I'll just go back. I do see one question in the chat, but if you do have a question, I'm going to go ahead and just, I think I will try to move it over. So, okay, I'm just going to go ahead and stay in the chat because people aren't moving it over to the Q&A. But anyway, so the one question is, what's the best time to start and apply for PERM within the 3-year physician waiver period? So the best time really is as early as possible. If the employer is willing to start the first year you start working, that's the best time, because it is such a long process that you don't want to start too late, so that you would actually, still be in the first or second step after you've completed your 3 years. So I would say if your employer can start the first year that you start working, that's the best time. But some employers are not willing to do that. So at least the second year of your J1 waiver would probably be another time, second best time to do that. So the other question is, while processing your EB2 visa, if your L1 expires, do you have to leave the US? Well, it depends on where you are in the process for the EB2. So if you are in the final step, the adjustment of status, and you've applied for adjustment of status, and you've applied for EAD for the work authorization, then you can stay. And in fact, you would need to stay in the U.S. if your L1 or L2 is expired. But of course, you would need your EAD to be approved before you can continue working, because once your L1 expires, you will not have any work authorization. So basically, you need to maintain your L1 status as long as possible until you at least get into the adjustment of status process and at least get an EAD. That's the best case scenario. Okay. Another question is there any difference in processing time frame on PERM, the employer, and other steps compared to NIW? Yes, there is a difference because, as I mentioned, PERM has many steps, as you can see. So you have the PERM process, which goes to the Department of Labor. That in itself can take a year and a half, just based on what we're seeing now in time frame, before you get to the I-140 stage. So that for you to even get a priority date, it might take a year and a half. Whereas NIW, you only have to do an I-140 to start your process. And once you file your I-140, you can even do premium processing that they have now for NIW, which is 45 days guaranteed processing. And now you've established your priority date earlier. And if your priority date is eligible, you can also go immediately into the adjustment of status phase or the consular process phase, immigrant visa process phase. So yes, it is definitely typically faster to do an NIW. And if it's approved, it's going to be faster than a PERM process if you're eligible. Let's see, there's one more question here that says, can you withdraw on EB2 NIW? And is there petition? And is there any downside to withdrawing? So yes, you can withdraw an NIW petition. I don't know of any downside to withdrawing. It's just because you withdrew an application, it does not mean that you're not eligible for any other application or not eligible to reapply for an NIW. So sometimes people will withdraw because there's an RFE that doesn't have, that they can't adequately respond to, or they might withdraw for any other reason. They don't want to proceed with it and decide to go another route. Those are all valid, but there's no penalty for doing that. Okay, so let me see if there's any more questions. Okay, I see one more question, and then we'll have to end because we are pretty much at the end of our time. And I want to thank everyone for spending the time here today. So the last question is, if you were already waiting for a petition for a green card, can you apply for PERM? And the answer is yes. There's no restriction or no limit on the numbers of applications that you can apply for or submit. So if you have a petition that's pending and you want to go ahead and, as a backup, have PERM filed, then you can certainly do that as well. So before we end, I just want to again remind everyone that the presentation, the questions, Q&A, all those things are informational. They're not legal advice. Everybody's case is different. So while information is good, it's not necessarily advice. And so to seek advice, please feel free to contact us. You will receive some follow-up information. You'll also receive a recording of this session. So you feel free to contact us at any of the contact points that we've provided. I want to thank you all for attending today. I really appreciate your interest, and we had great questions. And do take some time if you want to review all this information, because I know it was a lot. So again, thank you all for attending, and have a wonderful day.